And Tony and we spoke a few weeks ago about some prevailing legal issues that we see on a daily basis and that clients come to us with. And it was such an overwhelming success that we decided that it was time to schedule another hangout. So this afternoon, I just want to talk with Tony about a few different areas of law that I know he's very well versed in. And the first thing that I want to talk to you about, Tony, is something that I'm sure that you see day out, day in, day out in the trenches when it comes to auto accident cases. And one of the first things that I know that insurance companies do when they hear that someone was involved in a car accident and they may have been injured is they will call that person up and they may befriend that person in an effort to get a statement from them. How do you, approach that situation, and how do you advise clients when it comes to talking with an insurance company or not talking with an insurance company?
Well, when a person has been in a car accident, Jonathan, and the question you're posing is, what should they do when the insurance company for the person that caused the accident calls them up? And I might be a little different than some attorneys. My standard advice is you can give them some limited information, and you certainly do not want to be recorded. And the reason for that is if it was a significant accident, your car has been towed somewhere. The insurance company has no clue where your car is. They need to be able to adjust your car damage, and if they believe that the liability is clear, they will do that. So I tell people to, when the insurance company calls, to let them know, here's where my car is, and please go ahead and get an adjuster out there, and where can I go pick up my rental? Because in Ohio, they're entitled to the reasonable value of a rental car, and many of the companies will balk at that. And then I also tell them to report it to their own insurance agent. The agent's not going to take a lot of information, but at least it's going to be reported. And the reason you want to do that is if the person who caused your accident, if they're not on the ball, if they're some out-of-state company that's trying to get a local adjuster to do something for them, you may be sitting there, you may be forced, or they may dispute liability for some reason, so you may be forced to go through your own insurance to get your car taken care of. So, but the key thing is, don't give a big long statement about your injuries. Tell them, hey, I'm injured, I'm under a doctor's care. I will talk to you more about it down the road. I'm probably going to at least consult with an attorney, and thank you very much for the call. You don't want to get on the phone, let them record you, and what they want to do is they want to figure out were you speeding. So, just off the top of your head, they go, well, how fast were you going? And maybe you don't really aren't even thinking about it, and give them some number without thinking. You don't tell them all of your injuries. You kind of forget about something. So now they don't believe you when you tell them this other part of your body's hurting. And so don't give them evidence that they can use against you. Give them a little bit of information so that they can at least get your car taken care of, so you can at least have some transportation so somebody can take you to the doctor, presuming you got significant injuries. So, you'll go to different websites, Jonathan, on the internet, and you'll say, before you see these guys, before you talk to an adjuster, get my book or call me. And, it's great to get a free consultation with an attorney, and the sooner you do it, the better off you are, because they don't teach these things in grade school, high school, or even college, or even law school sometimes. So it's great to get that, initial information from an attorney. They're not going to charge you anything. Call them also. But when the insurance adjuster calls, at least give them enough information so they can get your car going. That's my take on it anyway.
Okay. Now, I've seen a lot of auto insurance companies. What they do is, after the accident, what they'll do is they may try to talk to a person. If that doesn't work, what they'll do is they'll put a bunch of forms in the mail. Some of those forms contain medical authorizations, which allow the insurance company to have access to their medical records. And some people, they're just, very carefree about things, and they just, scribble away and they send them off, and they don't really think twice about it. How do you, as a lawyer who's counseled many people who've been in these accidents, how do you counsel them in terms of responding to a request for a signed medical authorization?
I would tell them, definitely don't do it initially. If they have and I turn down cases every week. There's some cases that are just so small, they went to the emergency room and they say they're fine. And, I counsel them, don't settle your case yet. Make sure, let a month or two goes by. The insurance company will come at them right away. Hey, here's $1,000. And people think, okay, I'll take it. And then a week later, they really go stress themselves, and they got problems. It's too late. Hey, I just have them to answer your question. Don't sign a release. And now, Jonathan, it's not just that they're calling and sending you that. Now they're telling you to go to our portal.
Yeah.
Go to Geico's portal. Follow your accident. And, you download this release. You download this doctor's report. People would be shocked that not only do they get the records, they send this doctor a little one-page questionnaire where he can hardly put in anything, and if the doctor thinks that you're fine because you haven't come back to see him because you went to another specialist, now you got evidence against you. And plus, I've seen him with a general authorization to go to a hospital for a specific emergency room visit, ask for every bill and every treatment record that somebody's ever had at that hospital, hoping they're going to find some type of previous injury that may arguably be related. So the bottom line is, unless you've talked to an attorney, unless the attorney said, look, this is a simple case, you sound fine, you went to the emergency room, you can handle this on your own, here's an idea of what to do, then you can, if you want, be very specific about the authorization you give, or just go get the medical record yourself and send it to them, because they do need a basis to pay the settlement. But in terms of a significant case, never ever give that insurance company information. It is an information game.
Got it.
We, as the personal injury attorneys, on behalf of our clients, want to get them as much as possible. The insurance company wants to pay them as little as possible. We will drip the information to them as needed, as we vet it. It's not meaning we're going to change any records or, hold something out particularly, but we want to look at it. Sometimes mistakes are made, and you can get an addendum to get those corrected so that it doesn't hurt the client. So the bottom line is, in any type of significant injury, call an attorney before you sign anything.
Okay. Good advice. Now, we were just talking about medical care following a car accident and medical records and authorizations. I guess before we even get to that point, the injured person needs to go to a doctor. And a lot of times, people who are involved in a car accident, they may not have had They may not have been injured in the past. They may not have, a primary care doctor. And I understand that you're not a doctor, but as an attorney who's seen, certain patterns develop in these cases, how do you counsel clients in terms of, getting a doctor or getting medical attention after an accident?
Well, Jonathan, as you know, as a personal injury lawyer yourself, a good doctor is more critical to the person's case than a good attorney, because we can't create the evidence. We can't help the person really get better. We can facilitate that. So I will tell my clients, normally if they've been significantly injured, they've been carted off to the hospital by the Life Squad. And some of these hospitals will give you a follow-up referral, and it's primarily to one of their own in-house doctors who is a medical doctor. And that can be all right initially. I'll definitely tell them, if they have a family doctor, to contact their family doctor. And then it depends. Again, we're not doctors, but we're in the medical legal field. We know how to trying to help them. We've got more information than a lot of people do. So if it's an orthopedic injury, if their neck is hurting, if they're complaining of pain down an arm, that always kind of gives us a clue that maybe this just isn't a strained muscle. Maybe they've herniated a disc. It's causing radiating pain. Sometimes it's really hard to get into orthopedic specialists. I like to see clients get an appointment with their family doctor as soon as possible, because you can usually get in. And at the same time, it doesn't hurt to try to schedule an orthopedic specialist to see you if it's an orthopedic injury. If it's a concussive type of injury, if you got your bell rung and you're having a little memory problems, a little dizzy problems, it could be any kind of symptoms, headaches. Again, your family doctor, if you've had a relationship with him, he can be a quarterback and refer you on to, that would be, for instance, a neurologist. Sometimes these family doctors, though, Jonathan, and I bet you've seen it, they try to treat the patient for a year without referring them out. And, they should have been referred to a specialist. You have to be proactive in your own medical care. You can't just sit back anymore. And so really, if it is an orthopedic issue, that I would definitely go make an appointment with an orthopedic specialist as well as my family doctor, and then go from there. It certainly is a prudent thing that I tell people to do.
Gotcha. I think it's always good advice to be your own advocate in these situations, because otherwise, the way I see it is that these insurance companies will just, they'll take advantage of you, and they'll just second guess every decision that you make. One of the things that I've been hearing about, it's not so much of an issue in Illinois, but in other states, is after an accident, someone may have been involved in an accident today, and sure enough, tonight, tomorrow morning, tomorrow afternoon, their phone starts ringing, and it's not from an insurance company, but it's from it's hard to believe, it's from chiropractors in their area who are actually calling them, sort of inquiring to see if they need medical attention after their accident. I'm just shocked that that's a legal thing to do from an ethical standpoint. It just seems like there's a lot of whole can of worms there. Is this something that you're seeing, and if so, how do you suggest people react to it?
Well, Jonathan, that's very true. I have plenty of clients that tell me that I just got a call from someone who says, the insurance company is going to want you to do this and get examined, and you can come and see Dr. So-and-so. We'll send a cab out for you. Won't cost you anything. And that is a very aggressive chiropractor who's hired some service. You do not want to do that ever. You just don't, because the first thing is, even if this is a good chiropractor and not somebody who's going to run up some gigantic bill, try to glom onto your med pay out of your own policy of insurance so that you can't use it for anything else. Just think about, if you've hired that doctor and you've been with him for 3 months, you haven't seen anybody else, your case gets into the litigation process in part because you saw a chiropractor for the first 3 or 4 months, and they say, Mr. Client, in a deposition, the defense attorney says, how did you get to chiropractor so-and-so? Well, he called me up. A service called me. Well, that goes over like a lead balloon, and that just took the credibility right out of your case. So I'm not against chiropractors. I have one I go to myself. $30 in and out the door. He gives me a snap, crackle, and a pop, and I'm usually in pretty good shape. I got a low back issue myself, and in some cases, if that's, the medical profession will often refer you down the road to a chiropractor as an alternative treatment. But to go to somebody that's calling you up out of the blue, and you can count on 1, 2, 3, 4 chiropractors calling you, and it's also a little bit sad to say, you can count about 5, 6, 7 lawyers writing letters in the state of Ohio because they're allowed to do that. And they might be okay lawyers, but you never want to go to a chiropractor that calls you up. And I'm not going to say that you never want to go to a lawyer that sends you a letter, but you certainly don't want to hire a lawyer on the basis of a letter. Just like you definitely don't want to go to the There's enough good chiropractors. If your case is a soft tissue injury, and it's mild, maybe that does merit a chiropractor, you can find a good chiropractor. Attorneys who've done this for many, many years know the good guys that are reasonable and are trying to get these patients better, and in short order, if they don't, they refer them off to orthopedic specialists and trying to just build a system. So yeah, it's a real issue, and there's some guys that just you want to stay away from, and especially the chiropractors that are calling you on the phone.
It sounds like the Wild West out there in the heart of the Midwest.
Well, we're for Ohio is for a conservative state. We kind of we got it all here. We really do. It's just we're not behind, so far behind. We even got gambling in Cincinnati now, Jonathan, a Horseshoe Casino.
Stop tempting me, Tony. I mean, no, but one of the things we were just talking a little bit about, we're sort of kidding about, the aggressive chiropractors out there, but there's sort of there's a whole nother demographic of people who are involved in these car accidents that, for a long time has sort of gone really misunderstood. And in that sense, I'm really talking about people who've got, a closed head injury. They may have hit their head on something. They may have snapped their neck very quickly. They may, really not have a full understanding of what went on after an accident. Maybe they never really lost consciousness, but they're dizzy. They start, feeling a lot differently after an accident than they were before. With this particular group, and I think it's fairly universally accepted that they had some type of closed head injury. What do you, how do you handle these cases in terms of these, relatively minor closed head injuries, or sometimes in the case of a more significant closed head injury? How do you convey the significance of that to the decision makers, either at the insurance company or to the lawyers who are defending the case?
Well, Jonathan, it's you know, you can have a concussion is what you're talking about, and then a concussion is a brain injury, and if it's not life-threatening, unfortunately, it's given the misnomer, the misname, mild traumatic brain injury. And it's really not mild. Weeks or months after the accident, even though the person did not have a brain bleed on a CAT scan, but they did lose maybe consciousness for a little bit. Maybe they don't remember all the facts of the accident. Even if they didn't hit their head that they can remember, it's just a jerking back and forth that causes the brain to hit the skull, can cause a brain injury that, you know, instruments can't see, but that we know, and the research that's been coming out tells us that even with one concussion, you can have significant issues, memory problems, headaches, dizziness that last a long time, and people really have a difficult time getting the proper care sometimes, especially if they've been in a car accident, because there's still that cynicism that, oh, you really didn't have anything on MRI, this is a soft tissue injury, really a neck problem, but it's a concussion problem, and hopefully they've got a great family physician or an orthopedic physician that sends them to a neurologist. But the neurologist, Jonathan, as you know, is really going to look at gross things, and 99% of the time his examination is going to be normal, but the person still has these symptoms. So the real expert in this area is the neuropsychologist, the people that are not MDs, that are psychologists, that give all these tests. And you know, I'm learning more and more about it because you know, as we speak, I'm looking at neuropsychologists that the family member is saying this person has not had problems with their memory, and the neuropsychologist says, yeah, there's some findings here, but they really can't be related to a concussion because it was just one concussion and it was mild and there wasn't anything wrong. Well, you know, they're not up on the latest research, unfortunately, so that's where you try to, you know, I don't like to suggest to my clients what doctors to go to because, again, there's a built-in, well, the attorney told you to go there. But you know what? We have a duty to try to help our clients get better and maximize their compensation. And if we know of those neuropsychologists that are highly credentialed, that are up on the research, and that are not jaded by this was a car accident, we'll call it as it is, that, you know, the client, which seems obvious to me that it's related, will get a fair shake. And that's not to say that they're going to find it's always related or find that you have a deficit, but at least they're going to get a fair chance in an unbiased view, and it's really the neuropsychologist that you have to go to when you have those subtle problems and no real objective things that you can look at on X-ray. They're developing new tests all the time, but you know, now, Jonathan, just here in Cincinnati, the hospitals are taking over a lot of the medical care, buying the medical practices, and they are being bought by insurance. So you've got all this, you know, things to sort of conspire against a person that's injured, especially that's in a car accident. So, you know, again, if they can get a great doctor to help them, and if we can help them find a great doctor, and if they can get a great lawyer to help them, these people have a chance to, A, get better and get fair compensation for what the heck they've gone through. They didn't ask for this, Jonathan. You know, your clients that are horribly hurt, they'd give all that money back just to be healthy. You know that's the case.
You know, I've never had a client and even after the biggest settlements out there, who is truly happy. Everyone out there, it's a bittersweet, situation where, it's a resolution to a problem that hopefully allows them to move forward. But, that being said, I'm sure that everyone out there, with a big check would much rather exchange that for their health. One of the things that you just mentioned that I just want to follow up with you on is, sort of documenting these intangible type of injuries. And one of the things that I always do with auto cases and really any type of personal injury cases, I always have a family member, a spouse, a parent, or cousin even. I always list them as a damage witness.
Yes.
To help them, substantiate some of these, intangible type of changes that may have manifested after an accident, be it a real significant, auto case or a more minor injury. Is that something that you typically do?
Yes, Jonathan. That is a great way to show. Well, the insurance company, in the first place, you can have a friend write up a little statement and incorporate that in your demand packet to try to resolve these things. None of our clients really want to go to trial, let alone litigation. If you can resolve the claim, if you work it up great for them, get all the evidence, get a great packet together, and get that case resolved for them pre-suit, everybody's much happier. But yes, what my mentor called them, and I didn't know what he was talking about at first, we call them lay medical witnesses, as these are friends, co-workers, especially someone that besides the spouse, someone not related to the family, especially a close friend or a co-worker that knew this person, knew they came to work every day, and maybe they got back to work after a week. And even more poignant is this guy kept working. I'd seen him at the end of the day, he'd been rubbing his back, he'd been moving around in his chair, but he didn't sit home and not work. He went and worked hurt. And so you get your lay medical witness, his golfing buddies. Geez, he was a great golfer. We used to go out all the time. Someone that they had hobbies with, that they enjoyed their life. In other words, in Ohio, Jonathan, we don't only have a line item in front of the jury for pain and suffering. We have a line item for loss of enjoyment of life. So that jury, if they think there's loss of enjoyment of life because they couldn't pursue their normal activities, they get compensation for that, as they should, and that lay medical witness can set that up. So yeah, that because the doctors, they kind of give it cold and clinical and pretty fast, and you got to slow them down, get them some exhibits to get this explained. But a person who knows this guy is not going to get any money out of it for testifying. Jonathan, I actually was a lay medical witness one time for a lady who worked for me, and it's exactly what happened. She came in, and you could tell that she was hurting, and she had a pre-existing problem, which was fine. I never noticed her rubber back ever until this accident. So I know firsthand how valuable a lay medical witness can be. That's a great point to bring up, Jonathan.
No, I'm just glad to talk about it. We were just talking about, the importance of work, and in terms of, a personal injury case. And I want to transition now and talk to you a little bit about another type of case that I know that you handle quite a few of, and that's construction accidents. And as a guy, who's out, walking around, Chicago and driving around, city streets during the summer months, I see construction projects everywhere. And a lot of these projects, they're sort of, it's not like, they're assembled fairly quickly, and a lot of times there's a rush to get a project done, particularly before the fall. In these particular types of cases, where you have these skilled construction workers who are out there, busting their behinds to earn a living. In these type of cases, if someone is injured on the job, they're working on a busy construction site and they're injured on the job, from a legal perspective, what type of benefits does the law in Ohio afford them when it comes to seeking recourse for their injuries?
Anyone in Ohio that's injured in the course and scope of their employment can get workers' compensation benefits, which primarily, and it's fairly meager to say, and it's sad to say, and it's been cut down as we've gone on through the years because of well, I'm going to say it, chambers of commerce favor the business people, and the business people got the money and they got the lobby, and so the worker, the benefits that they once have don't quite have what they used to have. They can get paid partially their wages for the most part while they're healing up. They can get medical care while they're healing up of their own doctor, although there's some legislation that they're thinking about. If you're on too long, you got to switch to a workers' comp doctor. So you get your, if you're making $24 an hour, you're only going to get part of your wages paid because it's capped at about $800 a week here in Ohio. You're going to get medical treatment, but you got to go through a managed care organization to get that approved. So there's all these kind of hoops. It's a battle, and then there's some small benefit if you got a permanent impairment. You get an impairment award. Ultimately, you can settle your case. And you can't sue your employer. Everybody, for the most part, when the employer has not always done something negligent, but done something a little bit that contributed to it, and then they treat the employee pretty crappy. But unless they fire you in retaliation for filing a workers' compensation claim, or they intend to hurt you, like putting a gun to your head, we don't have the ability. It's a trade-off. They're immune from a lawsuit. So what you look for, and I know you do this too, is there an independent third party that caused the accident? So, were you on the job as the electrician and the pipe fitter from another company dropped a pipe down on your head? Then you actually now have two claims. You have your workers' compensation claim. Now you have a claim for your pain and suffering, the rest of your lost wages, loss of enjoyment of life, that could be as valuable or even more valuable. And the two of them together, you don't get to double dip in Ohio. Back in the old days you used to, but by that I mean if workers' comp pays you something that you get compensated for in the third-party claim, we have a formula, you got to pay that back. And that's why I like to manage both cases. I do both. I don't ship one out. I want to know what kind of evidence is created, what's going on in both cases, and you can manage both cases to the benefit of the claimant. So, yeah, that happens in the construction industry. It happens to the Federal Express driver that's rear-ended in a car accident. He's hurt while driving around. He's got a workers' comp claim, and he's got a third-party claim against the person who caused his car accident. So, and they're complicated, as you know, also.
Yeah, I mean, it sounds like basically every single work-related injury should at least be looked at by an attorney with an eye towards potentially pursuing a third-party case. Is that pretty much a safe blanket statement to say?
Yeah, definitely. I mean, you really do want to see if there's someone else. It can't be a co-employee. That doesn't count because that is construed to be an employer. So if you're coming out of the parking lot and your co-employee rams into you, you probably in Ohio only have a workers' compensation case. But if it's the guy from the other business next door that hits you, even though you're in the parking lot, those are interesting cases. You may be leaving work, but if you haven't been out of the zone of employment, so to speak, in Ohio, again, it gets complicated. You can have a workers' compensation claim as well as a claim against a third party for their negligence, your pain and suffering, your loss of enjoyment of life, the rest of your medical wages that weren't compensated for.
Wow. I guess all this being said, you know, what I've sort of learned in talking to you today and in the past is that it is really, really, really important for any person who's injured to seek out an attorney who has experience with their particular situation. You know, I think that, you know, increasingly today, you know, we're seeing the emergence of some bigger law firms out there, you know, who may, you know, advertise a whole array of services. But I think, you know, particularly, you know, you've reinforced it today, if you are involved in a specific type of personal injury case, you need to have an attorney who has experience with that case, who can really look out for your best interest. You know, would you agree with that?
Yes, Jonathan, and as you know, everybody thinks that they can be a personal injury attorney, you know, especially for car accidents. They think we'll get the police report, we'll get some medical records. They'll get half the medical bills because they don't even realize all the different entities that are billing. And then they try to make some 1 or 2 page demand, and then they beat on their client to take that settlement because they don't want to push the case to litigation. They haven't prepped the case enough to put a great demand packet together. And frankly, I'm not going to take a small case that a client can handle themselves. I'm going to tell them. I try to judge if I can make the client some more money for them than they can make on their own. I can't guarantee anything. You know that. There's no guarantees, and every case is as different as a snowflake. But, you know, in this day and age, you know, be wary of who you're hiring. You know, do your homework with the internet out there, with people. See what you know, are they in the American Association for Justice? You know, just because they say they're in the 100 best lawyers, you know, did they buy their way in? Look at their website. Look to see what some of their history has been. Look to see what some of their results have been. Look to see what some of their clients say about them. Now, that past performance doesn't guarantee future results, and you know we have to put a disclaimer on there. That doesn't mean, but you want to get somebody that has a track record of dealing with these kind of cases, just as you doing personal injury, and especially if I was in Chicago, I know I would make a beeline if I had a nursing home injury because I know how much you've written about it, how much you've dealt with it, and so I can tell where I can't just tell if a guy sends me a letter, you know, what has he really done? You know, has he tried cases? Has he had hundreds of cases like this? Does he know what the heck he's doing? And there's a lot of great women. I don't mean he to be, you know, there. You know, when I started, there weren't many women lawyers. Now there are, and there's some really, really great ones. So it's not a sex thing. It's an experience thing. It's a compassion thing. You know, you got to be uncompromising, and you got to fight for your client. If you fight for your client, you know, Jonathan, your field will take care of itself.
You know, I hope that you know, people who, regardless of where they are, they take the time to watch this video because, you know, some of the pointers that you gave right now and today are things I think that people can use in any circumstance where they're injured, and frankly in really any jurisdiction as well. So I want to really thank you for taking the time to talk with me this afternoon. I learned a lot. I had a lot of fun, and I look forward to doing it again.
Jonathan, thank you for lobbing those questions out so I could answer them. I really enjoyed doing this with you. This is the second one in our series. If you want to call it a series, we'll do some more of these as we have, as we have some time. And thanks again. It was a great afternoon, well spent. Take care, my friend.
Bye bye.
All right.